Hey, have you heard? Meta said that pirating over BitTorrent is fair use. That's what's going all over the socials. That's what's going all over the news. All based on what this lawyer said to the court in a letter. Yes, we're back over in Kadrey v. Meta. And as usual, we're going to look at it and we're going to dig down to the truth of it. As you've probably figured out by now, that's not what they said. Yep, they're lying again. Just to summarize the case so far, Meta was sued on the basis that their AI was infringing because they took all these books, ingested it, and then Meta's llama model makes all of these outputs. And the outputs are infringing and the models are infringing and the models have little compressed copies of books and things like that. And all of that failed, if you remember, in the most spectacular way, because all of this was quintessentially transformative and absolutely fair use. The only way the plaintiffs were able to save the case is by saying that Meta got some of the data by downloading it through BitTorrent, which means they must have seeded some of it back, and that's piracy. And Meta claims that because that was for a fair use purpose, that it was all part of it and it was all covered. And that was basically what Judge William Alsop said over in Bart's v. Anthropic. But Judge Chabria went a different way, saying that just because everything you do with it was fair use, that doesn't mean how you got it was fair use. So the only way they were able to save this was by saying that, by necessity, BitTorrent meant that you were seeding back the files and distributing them to other people. And we'll get into some details on that. But first, let's see what this lawyer has to say and see what the claim actually is. Plaintiffs respectfully write to update the court on a development with significant implications for the court's consideration of plaintiff's motion for leave to amend. Plaintiffs added uploading relating allegations to the third amended complaint, and since that time, plaintiffs have discovered that Meta unnecessarily assisted digital piracy by others. So that's the thing. They can't say that Meta did anything wrong. They just facilitated that in others, because none of the AI stuff is anything wrong now. It's all fair use. Of many millions of copyrighted works, including plaintiffs' works, Meta, for understandable reasons, never once suggested it would assert a fair use defense to the uploading-based claims. That is an outright lie, as we're going to see. But remember this sentence, remember this wording, because this is the claim. Meta never even suggested it was going to assert a fair use defense here. Which, if you've seen my other coverage on this case, you already know that's wrong. Indeed, even in its supplemental brief regarding the remaining case schedule, Meta failed to mention, much less assert, a fair use defense. Even though that case schedule was about discovery and wasn't a response brief where you responded to allegations which they had already done and they had already asserted fair use, among many other affirmative defenses. Instead, Meta told this court it had already bottomed out discovery and would complete discovery it intended to produce by February 28. Yet at 10:49 p.m. this past Friday, February 27, Meta served a supplemental interrogatory response on its fair use defense. Meta's supplemental response now argues for the first time, that uploading pirated copyrighted works to other data pirates is somehow fair use. Well, imagine that. Imagine someone saying that. Meta makes the new factual assertions that the potential for a peer to upload data to other peers in the network is an inherent characteristic of the BitTorrent protocol, which is weird because that's what plaintiffs said when they first brought up the torrenting, and that Meta uploaded copyrighted works to other data pirates because it was more efficient, and in the case of Anna's archives, those datasets were only available in bulk through torrent downloads. Meta's belated supplement to its interrogatory response and assertion of a fair use defense to uploading was submitted after the parties filed their court-ordered briefing relating to plaintiff's motion to amend and the remaining case schedule, but it is quite significant to the issues under consideration. Meta's supplement shows that Meta's proposed schedule is unworkable and unfair, and that plaintiff's proposed schedule and pending request for a piracy expert, yet another piracy expert, best support the efficient adjudication of the remaining issues and coordination of overlapping discovery with entrepreneur media, which again is what this is all about. See my coverage of the entrepreneur case for how they're just using it to try and make things impossible for Meta to defend themselves. Plaintiffs thus respectfully request that the court grant their motion for leave to amend and enter plaintiff's proposed schedule. Respectfully submitted, Jesse Panuccio, ambulance chaser for Boy Schiller. Yes, Boy Schiller, the same people who defended Harvey Weinstein and orchestrated the smear campaigns against his victims, which caused even the New York Times to turn against them, and who's also known for surveilling witnesses and journalists and all sorts of terrible things, and who did all that work for the Biden family. Oh, and you remember Tanya Chutkan? When she was a lawyer, she was with them. Yep. That Boy Schiller. But anyway, that's who they are. All right, enough of that crap. We'll see what they were talking about, and we're going to get it from the horse's mouth. This is Meta's second further supplemental and amended responses and objections, and we know this is the one they're talking about because they attached it as an exhibit. They can't say, oh no, they were talking about something else. I don't want to hear, oh no, that wasn't really. Nope, this is it. According to them, this is the one they're talking about. It's a 24-pager, and we'll see what Meta really said starting on page 9. The alleged use of plaintiff's asserted works, to the extent it is shown to have occurred, is highly transformative in nature because it adds something new with a further purpose or different character, altering those works with considerable new expression, meaning, or message. To the extent plaintiff's works were used to train the meta language models, the purpose was transformative both in terms of purpose and expression. The purpose of the models and the use of text datasets is to create new original textual output, not to reproduce the content of the datasets with which it was trained. Indeed, all plaintiffs, every single one of them, have admitted that they are not aware of any output from any meta-language model that replicates any protected expression in their at-issue books. Bottom of page 11 of the PDF, which says 9, yes, it's confusing. Plaintiffs have not alleged that their works were used as data in any post-training and fine-tuning processes for any meta-language model, but nevertheless, post-training and fine-tuning processes similarly involve a highly transformative use of the data used in those processes, both in terms of purpose and expression. The data used in post-training and fine-tuning is used to fine-tune model parameters to improve the performance, quality, and behavior of the models and their responses. Aside from its highly transformative nature, Meta's alleged use also has substantial, non-commercial, non-profit, and educational, including research purposes. Meta is investing billions of dollars in research and development of state-of-the-art LLM technology that it is then making available to the public. It's open source. These LLMs were provided openly to the public pursuant to an open license that permits developers, researchers, and institutions to use and modify the Llama models free of charge. You can just download them from Hugging Face. Don't even have to pay Meta a dime. And people are making their own quantizations and distillations and fine-tunings and mergers and things like that. You can download those, run those on your own computer, use it as much as you want without some corporation looking over your shoulder. Which is the exact opposite of what the anti-AI neo-Luddites say, isn't it? The ordinary market for plaintiffs' works is the market for people to purchase and read the books and, possibly, to create derivative works from these books, such as for audiobooks and film and television adaptations. The meta-language models and their outputs do not serve as a market substitute for the plaintiff's asserted works, do not compete with those works, and do not harm the value of plaintiff's asserted works. Which is what we keep hearing with this market dilution thing. Plaintiffs have produced no evidence to the contrary, such as evidence of lost sales or other financial harm. To the contrary, plaintiffs have admitted that they are not aware of any such harm. Moreover, there was no market for licensing plaintiffs' literary works as training data for LLMs at the time Meta first Llama 1, or at the time plaintiffs filed their lawsuit, and there is no such market today. Plaintiffs have admitted as much in discovery. In any case, such a market would be for a transformative use. It would also be impractical, if not impossible, for companies developing LLMs to attempt to negotiate licenses with each individual book rights holder for various reasons, including but not limited to the amount of time and cost necessary to do so, would have precluded development of the models in the first instance, in particular given the time and costs relative to the de minimis value of individual works to the development of the models. Because these models work when you give them zillions of books to train on. So although the value of all the books together is high, the value of any individual book is tiny, minimal, and not worth mentioning. Meta's fair use defense also applies to plaintiffs' copyright claims based on the alleged torrent download of plaintiffs' works, including all theories plaintiffs have advanced to date in support of those claims. Plaintiffs have not articulated the factual or legal basis, if any, of their assertion that the alleged reproduction of plaintiffs' works during the download process, without any alleged distribution of such works to third parties, violated their rights under Section 106(1) and falls outside the court's fair use summary judgment order. Any such reproduction qualifies as fair use under Section 107 because it is part of Meta's transformative use of plaintiffs' works and thus falls under the court's summary judgment order. Fair use also applies to this theory because there can be no harm to the market or potential market of value of plaintiffs' works because the mere act of allegedly making additional copies during the torrent download process without actual dissemination of their works does not result in any third party obtaining a copy of any of plaintiffs' works and thus can cause no market substitution or other potential harm. So think about what that ambulance chaser guy said that they said. This is what they actually said. Plaintiffs have asserted a claim for unauthorized distribution under Section 106(3) and have argued that it only requires a work to be made available for download through a peer-to-peer network without proof of actual distribution to third parties. Fair use under Section 107 applies because the potential for a peer to upload data to other peers in the network is an inherent characteristic of the BitTorrent protocol used to download datasets used for the transformative purpose of research, development, and training of AI models. Meta used BitTorrent because it was a more efficient and reliable means of obtaining the dataset, and in the case of Anna's archives, those datasets were only available in bulk through torrent downloads. Accordingly, to the extent plaintiffs can come forth with evidence that their works or portions thereof were theoretically made available to others on the BitTorrent network during the torrent download process, this was part and parcel of the download of plaintiffs' works in furtherance of Meta's transformative fair use purpose. Fair use also applies to this theory because there can be no harm to the market or potential market or value of plaintiffs' works because the mere act of making their works available to third parties through BitTorrent without actual dissemination of their works, that's the important part. Remember that. They're not talking about the works actually being uploaded to people. They're just talking about the BitTorrent availability does not result in any third party obtaining a copy of any of plaintiffs' works, and thus can cause no market substitution or any other potential harm. So as long as they don't get a copy of it, you haven't actually distributed it. That's very different from what the plaintiff said, isn't it? Amazing what you see when you actually read the briefs. So yeah, here's Meta's reasoning. If you use BitTorrent to transfer files, you automatically, as soon as you download the first block, you start seeding those blocks to other downloaders. That's just inherently how the protocol works. You advertise it's available. That's not a choice. That's just part and parcel of how the technology works. Now, Meta, as we've gone over, and we saw their expert explain in detail, they did everything they could to avoid seeding. They turned it off in the client. They did things like made scripts that set the seeding upload speed to 0, did some other scripts to avoid it, and even firewalled it. So those packets cannot get through the firewall. So the only uploading here would be very incidental. It would just be those tiny amount of blocks that somehow made it through all of that, if any of them did. But as they point out, Plaintiffs can't even prove that that happened. They can't prove that Meta actually seeded any of their works. And if they did, it was anything beyond de minimis, just a block or two. If torrenting is necessary to exercising your fair use rights, and you take all reasonable steps to avoid seeding, and seeding just happens anyway as part of the technology, it all falls under the same fair use. That is what Meta's arguing. So now let's hear it more directly. In a response letter that Meta filed to them, Plaintiff's letter is based on the false assertion that Meta never once suggested it would assert a fair use defense to the uploading-based claims, including after this court raised the issue with Meta last November. First, plaintiffs acknowledged in their own portion of the party's December 12, 2025 CMC statement, and CMC is Case Management Conference, that on December 10, Meta finally answered by stating that it may raise fair use for the first time in this joint CMC statement. So that's back in December. Second, within that same CMC statement, Meta identified as a remaining legal issue for the distribution claim whether Meta's conduct constituted fair use, and stated that Meta has informed plaintiffs that it will be asserting a fair use defense based on its current understanding of plaintiffs' remaining claims and theories. Third, the same CMC statement specifically addressed plaintiffs' failure to seek discovery on fair use and Meta's willingness to supplement the interrogatory response. Fourth, at the December 19, 2025 CMC, plaintiffs' counsel specifically acknowledged Meta's claimed fair use defense to distribution and argued that it could be dealt with at summary judgment. And so here, they're quoting the plaintiff's lawyer, Maxwell V. Pritt is the guy's name. What a name, Pritt. Who said directly, Meta still suggests that it will raise some fair use defense. Remember, this was back on December 19. But it is very clear in the case law that peer-to-peer file sharing and distribution does not have a fair use defense. So they're disagreeing with Meta, but Meta still said it. So we would go to trial, have, show the torrenting, deal with any fair use defense that Meta wants to try and raise its summary judgment, and be done. They acknowledged it. In short, plaintiff's assertion that Meta never once suggested it would assert a fair use defense to the uploading-based claims, including after the November 2025 hearing, is false. And once the court denied Meta's request for a stay at the February 6, 2026 hearing, Meta promptly provided the fair use supplementation on February 27, 2026, the date it had informed the court it was targeting to complete outstanding written fact discovery matters in Kadrey. Meta's fair use defense against plaintiffs' remaining copyright distribution claim is primarily directed to plaintiffs' theories that they can recover for alleged copyright infringement under their distribution claim absent any proof of actual dissemination or uploading of their works to any third party. Meta's supplemental response explains how those claims, even if legally viable, would fail based on fair use. Even without fair use, if you download a torrent, but block seeding, and you're advertising that you have this available and that other people can download it, but you never actually seed any of the blocks, have you committed a copyright violation? I don't think so. You have to actually distribute it, which is another problem with those letters they send out to your ISP. Plaintiffs identify no additional fact discovery necessary to address the fair use defense as it relates to their distribution claim. Indeed, plaintiffs have repeatedly told this court they do not need any more fact discovery on distribution-related claims. In reality, the fair use issue will be one for technical expert discovery, as plaintiffs essentially acknowledge by seeking to dispute both the prior testimony of one of Meta's technical expert witnesses, Ms. Fredrickson Cross. Remember when we covered her? She was really devastating to the plaintiffs. As well as Meta's assertion that torrenting was more efficient and reliable. When the parties made their scheduling proposals, both sides knew Meta would be asserting a fair use defense, and yet plaintiffs continued to maintain they did not need any additional discovery. And that makes it pretty clear. That's from Catherine R. Hartnett of Cooley. So then let's see what this Panuccio guy has to say about it, since they've caught him in an outright lie. Oh, you know how liars operate, don't you? You know, the first clause, the first thing I'm about to read from him, you know, you have heard this from every sort of liar who ever tried to lie about you in the past. You've heard this. Meta's letter is notable for what it lacks. Meta does not dispute it was required to, but did not seek leave to amend its interrogatory response. No, they don't have to. Meta does not dispute that its amended interrogatory response raises, for the first time, new factual assertions concerning Meta's knowledge and policy about use of BitTorrent to upload pirated copyrighted works. They showed it wasn't for the first time. And whether uploading and distributing enormous amounts of pirated copyrighted content is strictly necessary to train LLMs. But as they pointed out, you haven't showed that they uploaded a thing. Just that they made available for upload. And Meta does not dispute that its amendment comes 15 months after plaintiffs moved to add uploading allegations and 4 months after this court said to Meta, I think that you know whether you're planning on raising a fair use defense to their distribution claim or not. And as I so often say in response to these assholes, so what? Instead of addressing these key issues head on, Meta focuses on one word in plaintiff's letter, i.e., whether Meta ever suggested a forthcoming fair use defense as to uploading. Because that's what it's all about. That's the only thing left in this case. Do you remember when I told you, back when I read his first letter, focus on that sentence, remember that sentence? Well, this was the sentence. Oh my God, and I gotta read the footnote. Meta's assertion that plaintiffs identify no additional fact discovery necessary to address the fair use defense as it relates to their distribution claim is bewildering. Plaintiff's letter specifically notes the brand new factual assertions in Meta's amended interrogatory response. The potential for a peer to upload data to other peers in the network is an inherent characteristic of the BitTorrent protocol, and BitTorrent was more efficient. But that's not a new assertion. That's been there ever since plaintiffs added torrenting to the case. What you're talking about now is new allegations that you made that you can't show happened. You can't show that Meta uploaded a thing. And even if you could, it was de minimis and part of fair use. If Meta knew in December that it would make their fair use defense it now articulates, why did it wait until after the February 5 hearing and until after the parties briefed the court's questions on prejudice and remaining schedule? But they answered that in the letter. First of all, they had told them back in December. We covered that. And second, the reason why they didn't file until later was because they were waiting on whether Judge Chabria was going to give them a stay. And when the judge denied them the stay, that was then when they came back with the briefing. Because that's how these things operate, you see. If there's going to be a stay, there's no need to file. The bottom line is this. Currently pending before the court is plaintiff's motion to amend and the parties briefing on the remaining case schedule. Meta's actual, not vaguely threatened or hinted assertion of a fair use defense to uploading copyrighted works to other parties with its brand new factual assertions eliminates any potential claim of prejudice Meta asserted regarding plaintiff's motion to amend and shows that plaintiff's proposed case schedule is a more realistic and fair path forward. Yeah, because they're trying to jumble in the entrepreneur case with it and force Meta to juggle two basically identical cases instead of syncing them up. Really, I don't know what kind of person it takes to be a judge to hear lawyers talking like this and not just slap them upside the head for being squabbling children. Especially this Panuccio bastard who just lied to the court again. We saw it. We read them. You heard it. Yeah, that was document number 694 in the docket uploaded on March the 4th. We haven't had anything since then, so I'll keep you posted on how it goes. But one thing's for sure and three things for certain. The plaintiffs are running scared, and they have been this whole time, because they have nothing and they know it. Thank you so very much for watching. Comments for the Comment God, shares for the Share Throne. Please hit like, subscribe, and the bell, and of course, donate.bogosity.tv. Keep me doing what I do through sprained wrists and rainstorms that I've had to stop and do edits because of massive thunder and lightning, and hoping the power stays on, either through one-time donations or regular support. Thank you so very much for watching. Until next time, stay strong and be free.